good morning, and welcome to the e-Discovery Zone, brought to you live from the ABA Tech Show in the lobby of the Hilton Hotel on lovely Michigan Avenue in downtown Chicago. This is Tom O'Connor of the Gulf Coast Legal Technology Center in New Orleans, Louisiana, along with Browning Marean of DLA Piper in places spanning the globe.
Now Mongolia.
That's right. And our special guest this morning is Judge David Waxse from the District Court of Kansas, Federal District Court of Kansas. Good morning, Your Honor.
Good morning.
Well, you asked us what we were going to ask you about, and we didn't tell you, but Tom and I have decided that we're going to give you extraordinary rulemaking powers. You're not going to have to deal with pesky rulemaking committees and the like, but you get to change the rules. And when we look at the 2006 amendments, if you didn't have to deal with the rulemaking committees, what rule or rules would you change?
The first one I would change is pretty simple. I think Rule 1 needs to be modified to make it absolutely clear. Well, let me back up. The way it reads right now, it says the court shall administer these rules in a manner to ensure the just, speedy, and inexpensive determination. I think what we're missing is an obligation on counsel to ensure the just, speedy, and inexpensive. So my proposal that I made at the Duke conference, that apparently is still in the rule committee process, is that we should modify that rule. So it simply says counsel and the court have an obligation. And what I think flows from that, we've said there's an implicit obligation of cooperation. This, in the notes, could be clear that there's now an explicit obligation of cooperation, because I think that's the best approach to getting at just, speedy, and inexpensive. So that'd be the first change I'd make. I suppose the next one, since Duke's in my mind, is I think it would be helpful to change Rule 27 to allow a court to get involved in pre-litigation determinations about preservation, because I think there's too much money being spent because people can't figure out what's the safe thing to do, and you don't want to start a lawsuit just to get your preservation obligation straight, but you could get a court's involvement. And you know, I practiced 30 years before I became a judge, and I don't think I ever ran into a use of Rule 27, which allows pre-litigation depositions, but it makes sense that you could then do pre-litigation preservation determinations.
Well, you've certainly touched on the thing that I think causes us out in the civil world the greatest difficulty, which is trying to figure out when our duty to preserve has been triggered. And then what the scope of it is going to be. And a real question is proportionality for us, because our clients are screaming at us about the costs associated with it, and whether or not we can really bring proportionality to bear is a continuing challenge for us, both in large cases, and Tom, you advise a lot of folks in the country. Are you finding them challenging as that as well? Well,
sure. What I would refer to as a small case, of course, I was on a panel yesterday with our friend Bruce Olson, who when I referred to a 200 gigabyte case as a small case, chortled. He felt 5 gigabyte of data or less was a small case for him. But certainly, even at that level, when you have a client who's facing costs in the neighborhood of $500, $600, $700 per gigabyte to prep material, and they're a small company and they're faced with 200 or 300 gigabytes of data, how do they handle that? How can they handle that? And there's been some, I think, renewed focus on sampling as a possible solution to that. I personally would like to see some more realistic pricing on the part of vendors, but yeah, proportionality is something we really struggle with in those smaller cases.
Since we were at the ABA Tech Show, and I've been thinking a lot about predictive coding, which is an interesting bit of technology, whether it's new or not. Certainly it's starting to get some traction. And I think what would be absolutely wonderful for the entire industry is if we were able to get some sort of judicial validation of the use of predictive coding to separate wheat from chaff in these large data productions. What type of information would you want as a judge in order to rule upon the use of predictive coding and say, yes, it was satisfactory, and so this large corpus you didn't look at because predictive coding said don't look at it?
You know, I think the first answer I give to almost all these questions is what I would look at first is whether you tried to get an agreement with the other side on whether this was the way to proceed, and whether, if you've been proceeding without their agreement, you check and see if you can get an agreement. Because the court's not going to get involved if you've gotten the other side in the discussion and involved, hopefully, in trying to figure out how do we do this in the most cost-efficient manner. So that's the starting point. The other, though, you know, it seems to me you just use the general principles that if it looks like it's effective and transparent, it makes sense to me. I mean, I don't have any problem with using any technique that you can come up with that'll get us at this cost-effective method.
But your statement about Rule 1 and just what you stated right there, Judge, seemed to imply that you're not seeing a lot of that cooperation and discussion and agreement. Is that because Judge Fasciola referred to the obstinate attitude of some attorneys in litigation once? Or do you think it's not understanding the technology, or maybe a combination of both?
Yeah, I think it's clearly a combination of both. I think one of the things we've got to do, though, is we have to change the culture of litigation. There is no doubt that, I mean, if you want to start real basic, I think the people that migrate towards litigation are generally aggressive, you know, people with strong egos that like to win. So that's got to be calmed down. Winning is not the goal of litigation. It's resolving a dispute. And yet I run into lawyer after lawyer who you can just tell is, no matter how minuscule the point, their goal is to win, even if it costs the client a lot of money to get that victory. So culture change is one thing. But I think the other is, gets back to almost the ethics of what your obligation as a lawyer is. It's competent, loyal representation. And I think one of the things that's missing sometimes, my definition of loyalty includes you're trying to save the client money. And it almost sometimes creates a conflict with the lawyer because you're not practicing law to save money, you're practicing law to make money. So you have to get the right balance of how do you do this project in a manner that you can still get reasonable compensation, but it's not costing the client a lot. You know, and one of the interesting things that I ran into again at Duke was we were talking about cooperation, and there were a lot of big corporate general counsel there, and one of them said, well, I don't understand how you think you're ever going to get lawyers to cooperate. And my smartass answer was, you know, if you as the client tell your counsel to cooperate, I think they'll start cooperating. And it's somehow, it's the culture even of the clients. They want somebody that's going to win every battle, as opposed to looking at the big picture. How do we resolve this dispute in a cost-effective manner?
Right. You know, one of my suggestions, which our HR department turned down as impractical, was I was going to get 26G tattooed on the arms of all of our attorneys. They said that would be unreasonable, but you know, I think a close reading of 26G, and I think particularly as Judge Grimm enunciated it, as I recall, it was in Victor Stanley first. That's a powerful tool to enforce. Are you seeing more activity around 26G in conjunction with Rule 1?
Let's put it this way, I'm using 26G a lot more, which I hope will get attorneys focused on what it says. In fact, I've told Judge Grimm I'm now having Mancia hearings.
Because versus Mayflower, that was
what I do is bring the counsel in and tell them before we start the hearing I have a gift for them, and I give them a copy of Mancia and tell them I want it read before we start the hearing. And I go out of the courtroom, and I've done it several times now, and leave the law clerk in there. And each time she said, it's just amazing to see the change of their expression as they, for the first time, read that opinion, which makes them focus on 26G, and they know they're in trouble, because either in the request or the response, there are numerous violations.
Well, it's you know, it really is a sea change. I think one of the challenges for attorneys, again, clients do want us to be aggressive. I don't think that they're, if you say, well, I'm going to cooperate, I'm going to tell them what our systems are, I'm going to tell them which custodians we've gone to, I'm going to propose, you know, a series of things, and my great fear is they're going to say, well, Browning, I want a real lawyer. And I think that unless and until we get that cultural change that you're talking about, that I think we have a long way to go.
The flip side of that, and I'm interested in the judicial perspective of this, we hear anecdotal evidence or anecdotal recountings of many cases being settled rather than deal with the e-discovery issues. Do you see any evidence of that?
Yeah, it clearly is out there, because not only we need a cultural change, we need a knowledge change. There are too many lawyers, and especially in-house lawyers, that haven't figured out what this involves and how to deal with it. So out of fear, they say that, well, it's going to cost too much and it's too dangerous, let's just get rid of this case. And it may be it's a case they shouldn't have had to settle at the level they're settling it.
Right. Related to that, are you seeing an increase in the knowledge level over what it was several years ago? Are we remaining steady? Are the attorneys any better at understanding the issues? Clearly,
there's more knowledge among the lawyers. It's growing. It's just not nearly where it should be yet. And obviously, part of the problem is, even though we've now been dealing with this for 10 years, the last time I read an article about education in this field, there are very few law schools that are putting any emphasis on this, and we've got to start training new lawyers on all the aspects of e-discovery, and we're not doing that. So we not only needed law schools, we need bar associations, and everybody needs to get involved.
Well, I think one very encouraging sign is our good friend Ralph Losey's put together really quite an impressive curriculum. I volunteered to be a part of it. I know you have too as well, Tom. And I think that if nothing else, it provides a roadmap for law schools in the fullness of time to bring in a curriculum that is going to be practical for them. One last question really relates to the issue again of proportionality, and you know, Pension Committee, Judge Shinlin's magnum opus of last year. The one thing that was missing from it, and understandably given the fact that it was involved $500 million, was a concept of proportionality. And my great sort of the question is, do you think it's going to be possible for us to build in a concept of proportionality into litigation holds so that there is no perfect hold other than save everything, but that brings companies to its knees? Do you think that there's going to be a trend in allowing a proportional response to holds?
Yeah, I think so. I mean, because to me, proportionality is a key component of how you get to just, speedy, and inexpensive. It makes no sense if what's at issue is $50,000, you spend $500,000 saving data. And again, I hate to keep harping on this, but proportionality should start with an effort to get the other side to agree on what's proportional. Now, if you've got somebody that's trying to improperly use discovery as leverage for some other improper purpose to get the case settled, that's not going to work. And that gets back to maybe a change in the rules so that you can go to court if you can't get an agreement on a proportional litigation hold. Because this needs to be looked at in terms of the big picture, which is how do we resolve this underlying dispute, not how do we have a nice game of e-discovery ball and go back and forth.
Right. Well, Judge, I think we're just about out of time, yes. But any last comments you'd like to make?
Well, I see real progress among lawyers. I just think we have a long way to go, and people have got to keep focused not only on the details of e-discovery, but on what's the goal of litigation.
Great. Well, thank you very much for your time. We appreciate taking time out of your schedule to be with us this morning. And this is Tom O'Connor and Browning Marean saying goodbye from the e-discovery zone.